Hello everyone, it's Harry. So, we begin with developments surrounding access to documents connected to the Jeffrey Epstein case and questions raised about redactions within those materials. At the center of the discussion is an email described by members of Congress who were granted access to review certain files at a Department of Justice facility. According to statements made publicly, that email references comments attributed to former President Donald Trump regarding his past relationship with Jeffrey Epstein. Lawmakers who reviewed the document say portions of it were redacted without a publicly provided explanation. Members of Congress, including Democratic Representative Jamie Raskin, were permitted to visit a Department of Justice facility to examine what were described as unredacted files. However, as explained during a recent discussion, those materials were unredacted versions of documents that had previously been released in redacted form, and even those versions still contained redactions applied earlier. In addition to those documents, lawmakers have raised concerns about another group of files described as numbering in the millions, which they say have either been withheld, categorized as duplicative, or remain otherwise inaccessible. Representative Raskin described reviewing one specific document during his visit. He stated that it was an email sent by Jeffrey Epstein to Ghislaine Maxwell. According to his account, that email forwarded a message Epstein had received from attorneys. The forwarded message reportedly summarized a conversation between Epstein's legal team, attorneys representing Donald Trump, and others during the period of the 2009 investigation involving Epstein. Representative Raskin said the summary quoted Trump as stating that Jeffrey Epstein was not a member of his club at Mar-a-Lago, but rather a guest, and that Epstein had never been asked to leave. Raskin indicated that this portion of the document was redacted in the publicly released version, and he said the reason for that redaction had not been explained through a privilege log or other documentation. The absence of a privilege log has been cited as a key concern. A privilege log typically identifies documents that are being withheld or redacted and provides a general description of the basis for withholding them, such as attorney-client privilege or another legally recognized protection. Representative Raskin stated that the Department of Justice had not provided such a log explaining why specific redactions were made. He also said that the redacted content appeared to conflict with more recent public statements made by President Trump about his past interactions with Epstein. During a congressional hearing, Representative Dan Goldman questioned Attorney General Pam Bondi about the same email. Goldman stated that the document he reviewed contained statements attributed to Donald Trump about his prior relationship with Jeffrey Epstein and asserted that there was no attorney-client privilege applicable to the email as it was sent from Epstein to Maxwell. He asked whether the unredacted version would be made public so that Americans could review its contents. In response, Attorney General Bondi referred to prior impeachment proceedings involving President Trump and stated that privileged objections were being sustained. The exchange did not produce a commitment to release the unredacted document. Representative Raskin later discussed his interpretation of the email. He said that the language attributed to Trump in the summarized telephone interview appeared to indicate that Epstein had been welcome at Mar-a-Lago and had not been asked to leave, which he described as being at odds with statements Trump has made more recently. Raskin also stated that thousands of documents were available for review in the facility and that this particular email was among the first substantive documents he examined. The broader context, according to Raskin, involves multiple layers of redaction and what he described as procedural obstacles to obtaining a complete understanding of the records. He characterized the process as involving multiple levels of deletion and redaction, which he said make it difficult to form a coherent picture of the events surrounding the investigation. He also raised questions about the number of documents withheld. Lawmakers have stated that approximately 3 million documents have been produced, some of which are partially redacted, while an additional estimated 3 to 5 million documents have not been made available for review. The Department of Justice has reportedly stated that some of the withheld materials are duplicative. In discussing legal standards, Representative Raskin said that federal law requires disclosure of these materials with redactions limited to the names of victims. He also claimed that in prior releases, Personal information such as names, addresses, phone numbers, and in some cases, images that should have been redacted were not properly protected. Additionally, he described concerns that congressional staff members were not permitted to assist lawmakers in reviewing the documents despite long-standing Supreme Court precedent recognizing the role of staff in supporting congressional oversight responsibilities. Another issue raised involved reports that the Department of Justice monitored which documents lawmakers accessed during their review sessions. According to Russin, materials presented during a hearing suggested that search histories had been tracked, which he described as an infringement on the separation of powers and on Congress's oversight authority. The discussion also referenced the Epstein Transparency Act. Lawmakers stated that the act requires the preparation of a report explaining redactions. However, they said such a report has not been provided. There was also discussion about whether the statute includes a private right of action or enforcement mechanism allowing courts to compel compliance. Representative Raskin stated that the current language does not clearly provide such a mechanism and that Congress may need to consider legislative amendments to establish one. Throughout the exchange, lawmakers maintained that they are seeking full disclosure of the materials subject to legally required protections for victims. They also stated that the process as it currently stands does not provide sufficient transparency. Attorney General Bondi, for her part, defended her position during the hearing and maintained that certain objections were privileged. The hearing included moments of personal exchanges unrelated to the document review itself. However, the central issue remained access to and explanation of redactions within the Epstein-related files and the scope of documents yet to be released. As this matter continues to unfold, questions remain about the total number of documents involved, the legal standards governing redactions, and the steps Congress may take to address concerns about oversight and transparency. In continuing our coverage, we now turn to the structure of the document production process itself and the distinctions lawmakers have outlined regarding what has been released, what remains redacted, and what has yet to be made available. According to members of Congress who have reviewed the materials, approximately 3 million documents have been produced to date. These documents have been described as partially redacted. Lawmakers were later granted access at a Department of Justice facility to review what were referred to as unredacted versions of those same 3 million records. However, even those versions were not entirely free of redactions. As explained during public remarks, an earlier layer of redactions had been applied by the FBI in March, meaning that while one layer of redaction may have been removed, other redactions remained in place. Lawmakers have described this as a layered process. The publicly available documents represent one version with redactions visible. The versions accessible inside the DOJ facility are described as more complete, yet still not fully unredacted. Beyond those 3 million documents, there are reportedly an additional 3 to 5 million documents that have not been turned over for congressional review. According to statements attributed to the Department of Justice, some of these withheld materials are considered duplicative or non-responsive. Lawmakers, however, have questioned that characterization and have asked for full access in order to independently verify the scope and nature of those materials. Representative Jamie Racine provided an overview of what he described as the universe of documents. He outlined multiple levels of deletion and redaction, beginning with the partially redacted 3 million documents already released, followed by the version accessible at the DOJ facility that still contains FBI-applied redactions, and finally an additional group of documents not yet produced. He noted that a single document may consist of multiple pages, meaning that the total number of pages involved could be significantly higher than the number of individual documents referenced. Concerns have also been raised regarding memoranda documenting victim interviews. Representative Rashin stated that there were instances in which individuals contacted authorities to report that they had been victims of human trafficking or sexual assault, and that internal memoranda were created summarizing those reports. He said that some survivors have reported that they cannot locate documentation of their cases within the 3 million documents that were released. Lawmakers have pointed to that absence as evidence that potentially relevant materials may be among the documents withheld. In addition to victim-related memoranda, lawmakers referenced prosecutor memoranda associated with what they described as an original 60-count federal indictment. According to statements made during the discussion, that indictment was ultimately resolved through a plea agreement involving a state count of solicitation to prostitution. The negotiation and circumstances surrounding that resolution were mentioned as part of the broader historical context. Representative Raskin referenced the involvement of then U.S. Attorney Alex Ayosta and Attorney Alan Dershowitz during that period, stating that lawmakers are attempting to reconstruct what occurred in connection with that federal prosecution. During the same discussion, questions were raised about oversight procedures typically used in litigation. Comparisons were made to the deposition of a person most knowledgeable in civil litigation, a process designed to identify the full universe of documents before issuing targeted requests or subpoenas. Lawmakers suggested that in this situation, Congress is attempting to reconstruct the scope of existing materials without a clear inventory from the Department of Justice. They emphasized that the DOJ is both the custodian of the records and the entity determining which documents are withheld, which they argue complicates the oversight process. A key point of contention involves the absence of a detailed report explaining redactions as required under the Epstein Transparency Act. Lawmakers have stated that the statute mandates the preparation of a report outlining the basis for redactions. They argue that such a report has not been produced. The Department of Justice has maintained that certain materials are privileged or otherwise protected. However, lawmakers have challenged specific privilege claims, particularly in relation to the email sent from Jeffrey Epstein to Ghislaine Maxwell that referenced a summary of statements attributed to Donald Trump. Representative Epstein stated that in his view, federal law requires the disclosure of all materials except for the names of victims. He asserted that attorney-client privilege claims would not override federal disclosure requirements in this context. He also argued that sharing information with third parties could negate claims of privilege. These legal interpretations were part of the broader exchange during the hearing. Another issue raised during the discussion involved the monitoring of congressional review sessions. According to Representative Raskin, documents displayed during a hearing appeared to show that the Department of Justice tracked which files lawmakers accessed while reviewing materials at the DOJ facility. He stated that in one instance, a document labeled with a member's search history was visible in what he described as the Attorney General's materials during testimony. Raskin characterized this as an infringement on congressional oversight authority and a violation of the separation of powers. He argued that members of Congress should be able to review materials independently without monitoring of their document searches. Lawmakers have also expressed concern that congressional staff were not permitted to assist in the review process. Representative Raskin noted that Supreme Court President recognizes the reliance of members of Congress on staff to carry out legislative responsibilities. He described staff members as essential to conducting thorough oversight, particularly when reviewing millions of documents. The inability to involve staff, he said, limits the capacity of lawmakers to conduct meaningful review. The conversation also addressed potential legal remedies. It was noted that the Epstein Transparency Act does not explicitly include a private right of action, which would allow individuals or members of Congress to bring a lawsuit to enforce compliance. Lawmakers discussed the possibility of amending the statute to create such a mechanism. There was also mention of a discharge petition as a legislative tool that could be used to advance amendments if committee processes stall. During the hearing referenced in the discussion, Attorney General Pam Bondi responded to questions from Representative Dan Goldman regarding the redacted email. Bondi stated that privileged objections were being sustained and did not commit to releasing the unredacted version. The exchange included references to prior impeachment proceedings, but did not result in further clarification about the specific redaction. Lawmakers stated that Republicans initially resisted voting for the Epstein Transparency Act, but later supported it after bipartisan backing emerged. They also referenced public statements by former President Trump indicating his support for transparency regarding the files. Throughout this segment of the discussion, the central issues remained consistent: the number of documents produced, the number withheld, the legal standards governing redactions, and the mechanisms available to Congress to compel fuller disclosure. Lawmakers emphasize that their stated objective is to obtain all relevant materials, subject only to legally mandated protections for victims. As these questions continue to develop, attention now turns to the broader political and institutional implications raised during the hearing, including exchanges between lawmakers and the Attorney General that went beyond document access and into issues of professional qualifications and public accountability. As we continue, the focus now shifts to the broader exchanges that took place during the hearing, including questions about professional conduct, oversight authority, and the responsibilities of public officials in the context of the Epstein-related document review. During the Judiciary Committee proceedings, the questioning extended beyond the technical issues of redaction and document access. In addition to inquiries about privilege claims and the absence of a redaction report, the hearing included pointed exchanges between Attorney General Pam Bondi and Representative Jaime Racine. These exchanges drew attention not only because of their tone, but because they occurred amid ongoing disputes over transparency and congressional oversight. Representative Dan Goldman's questioning of Attorney General Bondi centered on the specific email from Jeffrey Epstein to Ghislaine Maxwell that summarized statements attributed to Donald Trump. Goldman asserted that there was no applicable attorney-client privilege protecting the email and asked whether the unredacted version would be released publicly. Bondi responded by referencing Goldman's past role in impeachment proceedings against President Trump and maintained that privileged objections were being sustained. She did not commit to making the document public. Representative Racine later commented on the exchange and reiterated his position that federal law requires disclosure of materials with the exception of victim names. He argued that even if state-based privilege claims were raised, federal disclosure requirements would prevail. He also stated that the email in question was shared between Epstein and Maxwell, neither of whom were attorneys in that exchange, and therefore, in his view, it did not meet the standards for attorney-client privilege. Beyond the legal arguments, the hearing included personal remarks directed at Representative Racine. Attorney General Bondi questioned his qualifications as a lawyer, referencing his prior involvement in impeachment efforts. In response, Racine addressed the issue more broadly, stating that the practice of law is defined not by personal attacks, but by adherence to principles of justice and representation. He said that the role of a lawyer, in his view, is to identify with victims of injustice and criminal violence rather than with those accused of perpetrating it. The discussion also turned to the leadership of the House Judiciary Committee. Representative Raskin noted that Chairman Jim Jordan has not passed the bar exam and stated that, in his view, passing the bar is not necessarily a prerequisite for serving in Congress. He shared a personal anecdote about his father who graduated from law school but did not take the bar exam because he chose not to practice law. Raskin emphasized that individuals can contribute to legal and constitutional discourse regardless of formal leisure. In recounting his father's history, Raskin referenced events during the Vietnam War era. He stated that his father worked for President John F. Kennedy before founding the Institute for Policy Studies. He also said that his father was indicted along with Dr. Benjamin Spock and William Sloane Coffin for conspiracy related to draft resistance during the Vietnam War. According to Raskin, the convictions in that case were ultimately dissolved and his father was acquitted by the jury. He described the case as one in which the defense challenged the legality of the war and emphasized adherence to international law. Raskin used that example to underscore his broader point that standing for the rule of law does not depend solely on formal credentials. He stated that there are lawyers who, in his view, have acted unethically, and individuals without legal leisure who have upheld constitutional principles. In the context of the hearing, he said the focus should remain on transparency and accountability rather than on personal attacks. Throughout the exchange, the central issue remained access to documents and the legal framework governing their release. Lawmakers reiterated their concern that millions of pages remain either redacted or withheld. They stated that approximately 3 million documents have been produced, with additional millions yet to be released. They also emphasized that the Epstein Transparency Act requires a report explaining redactions, which they say has not been provided. The conversation also addressed the potential legislative path forward. Representative Raskin acknowledged that the current statute does not clearly provide a private right of action, meaning that individuals or members of Congress may not have explicit authority to sue for enforcement. He suggested that Congress could consider amending the law to create such a mechanism. A discharge petition was mentioned as a possible procedural step to bring such amendments to a vote if necessary. Lawmakers further indicated that public pressure and continued oversight could play a role in obtaining additional disclosures. Raskin referenced what he described as a growing community of survivors advocating for transparency and accountability. He stated that regardless of procedural challenges, information may continue to emerge through various channels. The hearing concluded with remarks emphasizing the role of the press in covering the issue. Representative Raskin stated that the press serves the public by reporting on matters of government accountability. The exchange ended with acknowledgments of ongoing efforts to review the materials and pursue further clarity regarding redactions and withheld documents. At this stage, the debate remains focused on several unresolved questions: the total number of documents connected to the Epstein case, the legal basis for specific redactions, the absence of a detailed redaction report, and the authority of Congress to compel broader disclosure. Attorney General Bondi has maintained that certain materials are protected by privilege, while lawmakers continue to challenge that assertion and call for greater transparency. We conclude tonight with a summary of the key facts and positions presented regarding access to documents connected to the Jeffrey Epstein case as described by members of Congress and addressed during recent Judiciary Committee proceedings. At the center of the matter is a body of records associated with the investigation into Jeffrey Epstein. Lawmakers have stated that approximately 3 million documents have been produced to date. These materials have been described as partially redacted in their publicly available form. Members of Congress were later granted access at a Department of Justice facility to review what were characterized as unredacted versions of those same documents. However, according to those who reviewed them, even those versions still contain redactions applied earlier, including by the FBI. Beyond the 3 million documents already released in some form, lawmakers have stated that an additional 3 to 5 million documents remain withheld. The Department of Justice has reportedly indicated that some of those materials are duplicative or non-responsive. Members of Congress have questioned that determination and have called for full access in order to independently assess the contents and relevance of those records. The total number of pages involved could be significantly higher than the document count itself, as a single document may consist of multiple pages. One document in particular has drawn focused attention. Representative Jamie Raskin stated that he reviewed an email sent by Jeffrey Epstein to Ghislaine Maxwell. According to his account, that email forwarded a message from Epstein's attorneys summarizing a conversation during the 2009 investigation period. The summary reportedly quoted Donald Trump as stating that Jeffrey Epstein was not a member of his club at Mar-a-Lago, but was a guest, and that he had never been asked to leave. Representative Raskin said that this portion of the document was redacted in the publicly released version, and that no explanation had been provided through a privilege log or similar report. Representative Dan Goldman questioned Attorney General Pam Bondi about that specific email during a hearing. Goldman asserted that the document was not protected by attorney-client privilege and asked whether the unredacted version would be released to the public. Attorney General Bondi responded by sustaining privileged objections and did not commit to releasing the unredacted material. The exchange did not result in a change to the document's status. Lawmakers have emphasized that the Epstein Transparency Act requires the preparation of a report explaining redactions. They have stated that such a report has not been produced. Representative Raskin argued that federal law compels the disclosure of these materials with redactions limited to the names of victims. He also stated that certain redactions appear inconsistent with that standard and that privilege claims should be carefully examined under federal disclosure requirements. In addition to concerns about redactions, lawmakers have raised questions about memoranda documenting victim interviews and prosecutor memoranda related to an original 60-count federal indictment that was ultimately resolved through a plea agreement involving a state count of solicitation to prostitution. Representative Raskin referenced the involvement of former U.S. Attorney Alex Ayosta and Attorney Alan Dershowitz during that period, and stated that Congress is attempting to reconstruct what occurred in connection with that prosecution. Another issue raised during the hearing involved reports that the Department of Justice tracked which documents lawmakers accessed while reviewing materials at the DOJ facility. Representative Raskin stated that materials shown during testimony appeared to include a record of a member's search history. He characterized this as an infringement on congressional oversight authority and a violation of the separation of powers. Lawmakers also stated that congressional staff were not permitted to assist in reviewing the documents, which they argue limits their ability to conduct comprehensive oversight. The hearing included moments of personal exchanges between Attorney General Bondi and Representative Raskin. Bondi questioned Raskin's qualifications as a lawyer, referencing past impeachment proceedings. Raskin responded by discussing broader principles related to the practice of law and the role of attorneys in upholding justice. He also addressed questions regarding bar leisure and referenced his father's legal background during the Vietnam War era. Those exchanges, while notable, did not alter the central dispute over document access and transparency. As of now, lawmakers have stated that the Epstein Transparency Act does not clearly provide a private right of action, meaning there may not be an explicit enforcement mechanism allowing courts to compel compliance. Representative Raskin indicated that Congress may consider legislative amendments to create such a mechanism. A discharge petition was mentioned as a possible procedural step if additional legislation is pursued.